First question. Rescission of a voidable contract is communicated and revoked in the same manner as the communication and revocation of A. Proposal, B. Acceptance, C. Breach, D. Impossibility. It's proposal. It's similar to proposal. Okay. Second, a servant is employed for 1 year on a monthly salary of 1800. The whole salary is to be paid at the end of the year. The servant wrongfully leaves the service after 6 months. Is he entitled to any salary? A. He is entitled to whole salary. B. He is entitled to the salary of 6 months. C. He is entitled to salary which his master thinks suitable. D. He is not entitled to any salary. Now the servant here leaves wrongfully after 6 months. So the first thing that comes to our mind is at least the servant should get salary for the 6 months that he has served his master. But it is important to note that he has left the service wrongfully. So once the servant leaves the service wrongfully, he will not get any salary. If he had left the service for some sufficient reason, for a reasonable cause, then probably he would have got 6 months salary, the period that he has worked. But here the servant has wrongfully left, so he shouldn't be entitled to any salary. Let's check. That is the answer. Next, A enters into a contract with B for dancing at his theatre for 3 nights and for a fee of rupees 2 lakhs. A dances for 2 nights and is fallen ill. What remedy is available to B? A. B can repudiate the contract. B. B can claim damages from A. C. B is not bound to pay fees. D. B cannot claim damages from A. Now, look, the contract becomes impossible to perform here because B has fallen, rather A has fallen ill. Now, when you fall ill, it is obvious that you will not be able to dance at the theatre. So A did not go to the theatre for the 3rd night. Now, does B have any remedy here? B does not have any remedy here because the contract becomes void because of impossibility creeping in. A has fallen ill. Now it is impossible for him to perform, to dance. So this contract is void because of supervening impossibility. And when the contract is void because of supervening impossibility, there is no legal remedy that the parties have. So A will not be liable for any damages. That is, B cannot claim any damages from A. Okay. Next, X owes Y two sums. One for rupees 2000, which is barred by limitation, and another for rupees 2500, which is not barred. X pays rupees 1000 on account generally. Later, Y sues for rupees 2500. X pleads first as to rupees 2000 that it was time barred, and second as to rupees 2500 as part payment of 1000 is already done. Now, what are the options to you? A. Y can appropriate the payment of 1000 towards the first debt, and X is bound to pay 2500, which is not yet barred by limitation. B. Both the contentions of X are wrong. C. Either A or B D. Both A and B. Here you have to understand that this is the first debt and this is the second debt. Now the first debt has become barred by limitation. It has become time barred. And the second debt is not barred by limitation. Now I told you when the debt is barred by limitation, the creditor cannot recover the debt with the help of law, with the support of law. He cannot go to the court and say that, X should pay me, enforce the contract on X. He cannot get his right to receive, to recover the amount from X by the court. However, if X gives him some money, he can always appropriate it towards the time barred debt. So this is very important. X has paid Y on account. This is one more thing that needs to be understood. Here, X has not given any instructions to Y as to against which debt the payment has to be applied. So he has paid on account. So what does Y do? Y has applied the payment towards the first debt. Can he do that? Yes, he can do that. He can always do that. Since X did not tell him as to against which debt he has paid him, he can apply it towards the first debt, even though it is time barred. Even though it is time barred. So the first option is correct. Second option is also correct because both the contentions of X are wrong. As he can apply it, 2000 has become, even though 2000 has become time barred, he can always apply it. Y can always apply it, the payment of 1000 towards the debt of 2000, because Y received a payment of 1000. He can apply it, he can appropriate it towards the time barred debt of 2000. Second, now X says that he has made a payment of 1000 against 2500. Now Y has already applied this payment against the first debt. So the second contention of X is also incorrect. Y can rightfully do that. So the second contention of X is also incorrect. So both the contentions of X are wrong. That means both A and B. So the answer is both A and B. Okay. Next, where the performance of a promise by one party depends on the prior performance of promise by another party, such reciprocal promises fall under the category A. Mutual and concurrent, B. Conditional and dependent, C. Mutual and independent, D. Both mutual and concurrent and conditional and dependent. Look, the performance of one promise depends upon the prior performance of another promise. That means the promises are conditional and dependent. The first promise is dependent on the prior performance of the second promise. So it is conditional and dependent. Okay. Next, which of the following contract is not discharged by frustration? First, A. Government intervention, B. Destruction of goods, C. Change of law, D. Commercial impossibility. I already told you as to, in what cases does supervening impossibility occur? What are the likely cases? I told you government intervention. If government bans something, the contract becomes impossible and it gets frustrated, so it need not be performed. The goods are destroyed, the contract gets frustrated, There's a change in law which restricts you from going ahead with the contract is frustrated. Commercial impossibility. Commercial impossibility means it is commercially not possible to perform the contract. That is, if you go ahead with the contract, it will be uneconomical to you, it will be uncommercial to you. You might incur a loss. So, law says just because it is commercially impossible, you might incur a loss, the contract does not become void. You still need to perform it. The contract is not discharged by frustration. Okay. Next is impossibility existing subsequent to the formation of contract is called supervening impossibility. Subsequent impossibility, both of the above, none of the above. It's both subsequent impossibility or supervening impossibility. Okay. Next, supervening impossibility is related to A. Frustration, B. Quid pro quo, C. Privity of contract, D. None of the above. It is related to frustration, that is the contract becoming void because of impossibility of performance. Okay.